Organized fraud has evolved. Insurers and corporations no longer face isolated actors. They face capitalized, decentralized networks designed to extract resources with industrial efficiency. These operations execute complex, repetitive schemes at scale, ranging from staged auto collisions and phantom medical billing to faked hazardous material cleanups. Typically, corporations and insurers fight back by filing standard common law fraud claims in state or federal court. But a common law claim usually only allows a plaintiff to recover the actual money stolen by the defendants. If a network steals $1 million and only has to pay back $1 million when caught, the penalty functions as a standard operating expense. It doesn't dismantle a capitalized operation, it just taxes it. To actually destroy the network, institutional plaintiffs deploy a different tool, the Racketeer Influenced and Corrupt Organizations Act, or RICO. This chart illustrates the stark difference. While standard fraud recovers a base loss, like this $630,000 bar on the left, civil RICO requires that actual damages be multiplied 3 times, instantly turning a $630,000 judgment into nearly $1.9 million. We see this multiplier deployed effectively by massive institutional targets, like these CSX freight networks shown here. When CSX sued a ring of lawyers and a radiologist for concocting fraudulent asbestos claims, the federal judge didn't just award the $430,000 in actual losses. He hit the defendants with a mandatory $1.3 million RICO judgment. Reaching this financial threshold requires meeting a massive evidentiary burden. A plaintiff cannot simply walk into court and allege widespread fraud. To trigger federal racketeering damages, the plaintiff has to meticulously map the raw, mechanical facts of the fraud onto the strict structural architecture of Title 18, Section 1962 of the United States Code. The first structural requirement lies in Section 1962C. The plaintiff must prove that a culpable person conducted the affairs of a distinct enterprise. To see how this architecture holds up in practice, we can look at the recent default judgment in the federal case Allstate v. Toshner. The statute requires strict legal separation between the actor and the vehicle. In the Allstate case, the insurer mapped this clearly. They identified the orchestrators, Daniel Toshner and Lacey Davies, as the statutory persons, and the limited liability companies, Roadside Response and Responsible Billing, as the enterprise. This separation proves to the court it is looking at an organized criminal structure. It ensures standard corporate liability isn't prosecuted as racketeering. Once the structure is built, the plaintiff must prove that those persons committed specific statutory crimes, defined in the law as predicate acts. Common predicate acts in civil RICO rely on federal infrastructure, specifically the U.S. Postal Service for mail fraud, or telecommunications networks for wire fraud. But alleging fraud triggers a strict procedural gatekeeper, Federal Rule of Civil Procedure 9b. Rule 9b strips away the plaintiff's ability to use generalized accusations. The law demands particularity. The complaint must specify the exact who, what, when, where, and how of the fraudulent communications. Allstate met this burden by documenting hundreds of specific fake accident scene cleanup invoices that the defendants physically mailed to the insurer to extract payments. Without this level of detail, Rule 9b acts as a lethal filter, resulting in an immediate motion to dismiss. Even a perfect instance of mail fraud isn't enough. The statute demands a pattern of racketeering activity. The plaintiff must show at least 2 related predicate acts sharing the same purpose. Then comes continuity, proving these acts pose a threat of continued criminal activity. In Allstate, the sheer volume of repetitive fake invoices established this open-ended threat, proving the fraud was the core business model of the enterprise. This pattern requirement forces the court to recognize the behavior not as isolated torts, but as the core, enduring business model of the enterprise. To capture the entire network, plaintiffs add one final structural layer, the civil RICO conspiracy provision under Section 1962D. This provision carries a lower evidentiary burden. The plaintiff does not have to prove that every single defendant personally committed a predicate act like mail or wire fraud. The only requirement to trigger the conspiracy claim is proving an agreement. The defendants must have known about and agreed to the overall objective of the racketeering enterprise. This net traps tangential actors, administrators, and low-level participants who might not have mailed a fake invoice themselves, but actively supported the scheme. Pleading Section 1962D seals the perimeter. It stops participants from pointing fingers to escape liability, locking them all into the same structural framework. Once a plaintiff successfully proves this strict architectural framework, or the defendant's forfeit per a default judgment, the penalty phase triggers automatically. Under Section 1964C of the statute, the court has no discretion. It must award treble damages, and it must force the defendants to cover the plaintiff's attorney's fees. A clear example of this financial payload in action is the State Farm v. Linkow medical billing fraud case out of Pennsylvania. After a 4-week trial, a federal jury found that a network of healthcare providers had billed the insurer for unnecessary or non-existent medical services, awarding State Farm $4 million in compensatory damages. Because State Farm prevailed on their civil RICO claims, that award was immediately trebled to $12.1 million, levied jointly and severally against all the defendants. This specific mandatory financial payload breaks the traditional risk-reward calculus of organized fraud. It replaces the cost of doing business with total financial ruin. Facing that massive judgment, one of the defendants, Dr. Richard Mintz, attempted a strategic legal maneuver to escape liability. 2 of his co-defendants had previously reached settlement agreements with State Farm, and the court had marked the judgment satisfied for those specific individuals. Mintz argued that under state law, satisfying a judgment against one jointly liable defendant automatically satisfies it for everyone else. The federal judge rejected this defense entirely. Because RICO is a federal cause of action, federal law supersedes state-level satisfaction rules. This diagram shows how federal law applies the one satisfaction rule for multiple tortfeasors. The rule ensures the plaintiff only gets one full recovery. When co-conspirators settle, their payments are subtracted from the top of the total judgment bar, leaving the remaining balance intact. As we see here, those early settlements merely offset the total recovery. They do not release the non-settling defendants. The crushing weight of the remaining balance drops squarely onto the holdouts, preserving their joint and several liability. Civil RICO forces institutional plaintiffs to survive a brutal structural gauntlet of pleadings and proofs. But when executed correctly, it takes the fraud network's own organizational complexity and converts it into an inescapable financial trap.